This is Helping Seniors Television, the show all about helping seniors improve their quality of life. If you are of senior age, know someone that is, or plan on becoming a senior, then this show is for you. It's about helping you develop your own plan of action for aging, so you or a loved one can age actively and with dignity. Helping Seniors Television, from the Helping Seniors Network of Information. On this edition of Helping Seniors TV, host Joe Steckler talks with attorney Ruth Rhodes. Now, when it comes to estate planning and other legal issues, it's important to have an attorney with experience and dedication to the practice of elder law. Estate and medical planning, asset protection, guardianship, trust administration, probate, and other legal issues are important matters to discuss and to consider. Now, here's your host, Joe Steckler.
Welcome to this edition of Helping Seniors. My guest today is Ruth Rhodes, and Ruth is she's an attorney, but today we're going to talk about what we're calling a smorgasbord of legal matters.
That sounds like a good description.
Yeah. And the reason we call it a smorgasbord, folks, is that Ruth asked her paralegal to put together some of the most often asked questions that she gets from clients. And so what she did was she did that, and we put those into 10 or 11 questions that I'm going to ask Ruth, and she's going to talk about those today, because these probably are the things that sort of set the foundation for a good estate plan, being prepared for any contingency, being prepared for dementia.
Yes, I believe so.
What do you mean you believe so? You're an attorney, you're supposed to know so.
Okay, I know so. I know so.
Yeah, well, you gotta fight for yourself, Ruth.
Okay.
You gotta fight for yourself.
All right, thanks, Joe.
Okay, that's good. Ruth is also on our board of directors for Helping Seniors, and her recently was her first meeting she attended. What did you think of the meeting?
Well, I thought it was really interesting, and we have a lot of different personalities on the board.
Yes.
So I think you did a great job kind of herding all the cats together. And but I think it's really interesting. There's a lot of complicated things that the Helping Seniors is dealing with. And I can't wait to get started and learning everything that needs to be learned so that I can be helpful.
Yeah, well, last night we got in a Unity Church, the former Kaiser College over on US 1, offered us office space there, which we took. And we had a little agreement we had to sign, and I was going to sign it. Ruth looked over my shoulder and she says, "You want me to review that for you?" It's nice to have somebody on the board that will just look for and say, "Can I do that?"
Yes.
And that's what you hope to get on nonprofit boards, Ruth. It's very important.
Well, I hope that I can be a good service to you, to the whole firm, to the whole.
I have every confidence you will, because I also saw you making notes last night.
Yes, I was.
Yes, you were, and that's a good sign. But I have done so many television shows with different attorneys, and the very first thing that you put down and talk about was durable power of attorney.
Yes.
Why is a durable power of attorney so important, Ruth?
Well, I believe it's the single most important document you can prepare for yourself to protect yourself. The reason being is the Florida statute has a plan. If you forget to do a will, you never get around to doing a will. The Florida statutes have a plan for what happens to your property when you die. But the power of attorney, the durable power of attorney, is so important because it allows you to plan for in the event that you can't take care of yourself because of incapacity. And it happens to at least 1 in 3 of us. We're living longer, and a lot of us are being either Alzheimer's or dementia or some other incapacity is afflicting about 1 in 3 of us. So it's important to have a proper legal document in place to help make decisions for you in the event you cannot. And the durable power of attorney is I believe, one of the most important documents because it helps with all of your financial affairs. And if you have a good one in place, then you can avoid having to become a ward of the state through a guardianship proceeding in the event that you lose your capacity.
The key word that Ruth mentioned there is trust.
Yes.
Find somebody that you can trust, that you designate to act for you, because in a really, you can go into Office Depot and you can get a piece of paper like this, and it says durable power of attorney.
Yes.
Or you can go to an attorney and you can get that same piece of paper duplicated maybe 19 or 20 times, which contains all the powers that I'm going to designate for my beneficiary to act for me.
Yes. Now, there's a big difference between a form that I've seen come through Office Depot or come from Staples or come off the internet versus durable power of attorney prepared by Florida estate planning attorneys. There's a big difference. Oftentimes, I'm finding mistakes and problems with those forms that people are downloading that by the time we figure out there's a mistake, it's usually too late to fix it. But the durable power of attorney is a very specific document, like you said. If you don't have the specific power placed in the document, then the power doesn't exist.
Exactly right.
And the Florida law is very specific as to certain powers that have to be initialed and granted with initials. They're superpowers, and those superpowers deal with planning for Medicaid. And Medicaid's important because if you live long enough and you have to go into a nursing home, how are you going to pay for that? $6,000 to $10,000 a month for that, and most of us are having to rely on Medicaid to pay for that because Medicare does not pay for that.
That's important. We may talk about that a little bit, but you know, one of the questions you had here was, and the reason I'm going to go through all these things, and then we may go, if we have time, we'll go back and talk some other things, but these are 11 important things. I don't want the state to take my money, and that's frequently stated by the clients, but the question should be asked, like you hear, can the state take my money? What's the answer to that?
Well, it depends. It depends. Sometimes with the Medicaid program problem, the state could possibly take your money if you don't have proper planning put in place and you have had to go on Medicaid and you've used Medicaid benefits, then the state could try to recoup some of those monies back from your estate. So it's important to make sure you plan properly so that that contingency doesn't happen. But generally, the answer to that question is no. Generally, the state is not going to take your property when you pass. Is that the question?
But they can do it, though.
They can do it, yes. So that is why you have to have proper planning.
Right. I would feel very bad if I worked and saved my money and prepared for everything, and I lived long enough and healthy enough that I didn't have to spend it on care, that I wanted to give it to somebody that I had not put the correct documents in place that somebody could take it, that I didn't want to have a habit.
And that can happen. So if you don't have proper planning, like a will or a trust, then the Florida statute has a plan for your money. And it'll generally is going to take care of your spouse, your children, or a combination of the two. But what if you wanted to leave money to a charity, or what if you wanted to leave money to your best friend of 50 years? The statutes don't allow for that, doesn't provide for that. So if you wanted to do something like that, you would have to have the proper documents prepared. Otherwise, Florida statutes say this is how it's going to happen and that's how it goes, and there's no way around it unless you have a will or a trust.
I'm glad you mentioned that best friend of 50 years. I'm getting close to having my best friend for 50 years. It was number 46 the last time. We got 4 more years to go.
Okay, that's a big anniversary.
I hope I'm saying it right. I'll find out after the show if I've said it right or not. I'll find out. But you mentioned will and trust. Okay. What is the difference between a will, a trust, and which of these go to probate? And what is probate?
Oh gosh, that's a lot of questions.
Oh, I got them off my chest. Now you got to answer them.
Okay, so a trust is something that you create while you're alive, usually a revocable living trust, which means that revocable meaning that you can make changes for it. But what a trust is, it's a piece of paper, but it is treated as a separate entity from you that holds property that you put into the trust.
Okay.
And what that trust does is it allows you to either, while you're in charge of it, you're the initial trustee, and you can treat that property just like you do your own individual property now. But at some point, if you lose your capacity, that trust, you can use that to appoint someone that you trust to take over and manage your property while you're incapacitated. And then after you pass, they can take that property that's in your trust and use it to take care of your loved ones and distribute your property the way you direct them to. And generally that doesn't go through the probate process. Now, what the probate process is a legal way of changing title, and it's through the court system. A lot of assets you can take care of changing title upon someone's passing by just simply having contracts in place, or like a life insurance contract, or with your bank accounts, you can name beneficiaries, so you can avoid probate by doing that. But some things will have to go through probate to change title. So, for example, real estate. If you and your wife own a home, and one of you pass, and then the second of you pass, your children or whoever you leave your home to, unless your home's in a trust, it's going to have to go through the probate process so that your children can become the legal owners of the home.
So by going into a trust, you avoid probate.
That is correct.
Why is it good to avoid probate?
Probate is time consuming, for one. So it could take up to a year for a simple probate, usually 9 months to a year, for just a simple probate without any feuding or fighting in the family. But also it's public. Your will gets filed with the court. It becomes a public record. It's not always so easy for people to see, but it's out there and possible, for the public eye. So trust is more private. The trust itself will not get filed with the court. The only thing that gets filed with a court when you have a trust is just a piece of paper saying notice of trust that just lets everyone know that the person has passed away and that the person has a trust, and that's it, and plus who the trustee is. But there's no private information. They don't know how much money you had in your trust. They don't know who's going to be the beneficiaries of your trust, unlike a will where it's an open book. So if you're a private person, you would probably prefer a trust over a will.
I can see that. I can see that. Nobody's ever said that, explained that way. If you have a trust, do you still have to have a will?
I would say yes, you do. And but it's a special kind of will that works with a trust. It's called a pour over will. So it's like a pour over into the trust. So what it basically says, this special will, is that anything that's not already in the trust, I am pouring into the trust. So then your trustee would still be able to manage all that property and distribute all the property without probate.
Once you establish a trust, you have what they call a revocable and irrevocable.
Yes.
What's the difference?
Okay, so a revocable trust is a trust that can be amended or changed or revoked, just taken down altogether. Generally, that's how most people set up trusts. They set up revocable trusts.
Revocable.
Mm-hmm. Irrevocable trusts, there's two different kinds that I deal with. One is when you have a revocable trust that upon the person's death, it's no longer revocable. It can no longer be amended. It can no longer be changed. And now it is an irrevocable trust and will be distributed in accordance with the trust. Another way of doing an irrevocable trust would be possibly in some kind of asset protection planning or Medicaid planning where you're alive and well, and you take all of your property or whatever property you don't want to have control over anymore, and want to protect, and you put it in an irrevocable trust so that it's not available to you. It does a couple of things. If you get sued, then that asset is usually protected, or if you need to go into Medicaid, that asset is usually not counted as long as it's not within the 5-year look-back plan that Medicaid does. But the problem with irrevocable trusts, and the reason why a lot of people don't want to use them, is because they give up their power over that property. That's real hard to do. Yeah. And you have to have someone else take charge of your property, and you better be able to trust that person.
You have to be able to trust.
Yes.
back in 2011, I think it was, Florida passed a set of laws, and under that they had what they call the superpowers.
Yes.
When they did the superpowers, when they legislated that act, didn't it give an attorney or somebody a way to amend the trust?
Yes, yes. That's the superpowers that you're talking about is under a durable power of attorney. And those are those special items that have to be initialed by the person signing the power of attorney. And yes, one of those things that are initialed there allows your agent under the power of attorney to be able to make changes to the trust you created.
Yeah.
But they're generally not allowed to change the distribution. So they're not allowed
Okay.
to upset the way you wanted your property to eventually go.
Is it possible to disinherit or say, I don't want somebody, well, it's just it's like a two-part question.
Okay.
Can you disinherit a person from your will?
It depends on who it is that you want to disinherit.
Child?
If you want to disinherit your child, you absolutely can. You just be very straightforward with the language and say that I am not leaving anything to this child, and don't ever leave them just $1. That I hear and see that frequently. Don't do that, because if you leave a child just $1, then that child has the right to copies of your documents, notice of everything we're doing, until that $1 is paid. So that's a bad idea. If you don't want that child to get anything, you just disinherit them. Be very clear with your language that they're being disinherited.
Well, let's say that you had a child and you didn't want them to get anything. If you left something like a piece of property to them, then what you're saying is if I leave them a piece of property or leave them something, that gives them a chance to have access to documents?
That gives them a right to notice on a lot of the things, and if not all of the things that you're doing during the probate or trust administration, because now they're a beneficiary. Even though they're only a beneficiary of a specific item or a specific gift, they are still a beneficiary and have a right to access to copies of documents, copies of the trust, so they find out what you left the other kids. Yeah.
So the only way to do that then is just to put this specific language and say, I disinherit so-and-so.
Yes.
That's the way you have to do it.
That's the way I would suggest doing it. Because if you just don't mention that child and you don't say I specifically disinherit this child, and you don't mention otherwise, it could be argued by that child that you forgot about him or her, and that it was a mistake and you didn't mean to do that. And then they have a grounds for possibly contesting your will or trust. So it's really important to be very clear with your language and say, this child is disinherited.
And what we're talking about, that may sound cruel, but sometimes you have so many mixed up families, second and third and fourth marriages, that you, just to protect everybody, you might have to do exactly what we're talking about.
Yes, and I've had other situations where maybe one of the children are special needs, and that one child needs to have the bulk of the estate or all of the estate, and the parent needs to disinherit the other children that are doing fine. They have their own house and they're doing fine, and they just want to protect that special child that needs that additional help. So they will disinherit the other children so that the special child gets the whole bulk of the estate.
So what you're saying is that the use of the disinheritance thing is not just to specifically disinherit somebody, but in order to protect somebody, you'd have to specifically say, I disinherit the others?
I would suggest doing that so that, again, there's no question later about whether or not mom or dad forgot to write about me in their will. Just so that it's very clear that the special child, or whatever the situation is, that it's very clear that you didn't want them to inherit.
Do you find if you do something like that, it's best for the family to have a discussion as to why you would do that?
Some families are very open and honest with each other, and all the kids know what's going to happen and they're all on board. And then there's other families where the parents don't tell their children anything because maybe their children are estranged from them.
I can understand that.
Yeah.
Okay.
So it goes both ways. If it's an open and honest type family that have open dialogue with one another, I would suggest that they talk and make sure everyone understands what the plan is. But if there's problem people in the family, maybe that's not a good idea.
Let's say if I wanted to amend or change my will or trust, can I do that myself with a simple change, or write it written in, change an initial, or what do I have to do? Go through, have it notarized?
So if you want to change your will, I do not, or your trust, I do not suggest just writing on that document and initialing it or even notarizing it, because that could void your trust or your will. If you want to change your will, wills have to be done in a certain manner in Florida, otherwise they're not valid. So in Florida, they're required to be in writing. You can't do a verbal will. They have to be in writing, and they have to be witnessed by 2 witnesses. And in addition, if you want to avoid having a problem with your will being probated, just to make things smoother, you want to have it to be self-proved, which then also requires a notary. With the trust, the same thing. You would want to have 2 witnesses and a notary just to keep everything nice and proper and legal.
Okay. When we mention the word trust, it sort of brings to mind I'm trying to protect a lot of money or a lot of assets or something like that. What is, I think the best way to ask this is, why do you recommend using a trust instead of just a will if there's not a lot of money involved? Why?
Okay, well, for a couple of reasons. Trust may be proper, even though a person may have a modest estate. For one, a trust is a great tool for taking care of a loved one after you die, financially taking care of them, to manage the money for them, and have someone that in charge of their money and divvying it out to protect them, either because they may spend it all up, or maybe they have a disability and need someone to have oversight. Another reason a trust would be a good idea for someone with a modest estate would be if they own real estate. If you have real estate outside of the state of Florida, or even your home in Florida, you put those real estate properties into the trust, and then the trust can distribute the property without probate after you pass. And what's important about that too is if you don't have your real estate in a trust and it has to go through probate, then say a lot of people have a piece of property from up north, maybe when they used to live up there and now they're down in Florida. So if you have a piece of real estate in another state and it has to go through probate, not only will you have a probate in Florida, but you'll have an auxiliary probate in that other state too. So now you have 2 probates, and those can be avoided just by having a trust and making sure those real properties are put in the trust properly.
Okay, now, here's the case. You got a real devious grandparent, and that devious grandparent says, okay, I want to take, say if I had, let's make it easy, 8 grandchildren. And I want, knowing how the world works today, and what if I wanted to take $200,000 right off the top of my estate and give each child $25,000? And I wanted to protect that money so it would grow to be a retirement for them. Is it possible to set a trust up that would say, this money is put into a trust and it can't be accessed until a person is 65?
I mean, yes, you can potentially set up a trust that does that. It's probably not a good idea because there could be challenges made to the trust to make the money accessible, but it's possible to do something like that.
Well, I was just thinking, there's so many the kids today, they get money out of it from a family, and they go out and buy a car, and they don't think about planning ahead for the future. And if I wanted to make sure that I did something that they could remember, I say, my grandfather, he wouldn't give me the money, but I'm glad he wouldn't let me have access to it until I needed it. But if your person is 20 years old and a grandparent gives them $25,000, and over a period of 50 or 60 years, that could grow into a large sum of retirement funds.
It could grow. You're correct. But who would you put in charge? At 65, if they're 20 and you're waiting until they're 65, that's 40 years being in a trust. You'd have to set up successor trustees or maybe
what you do,
a bank.
I think what you do is you take the most trusting of those 8 grandchildren and make them the executor of the trust or something for the rest of them.
You could do that.
I'm saying.
Yes.
But I think the point I'm trying to make, Ruth, is that by going to an attorney, we can take all these questions that people ask, and by going to an attorney, they can help you figure out whether you can or can't do it, whether it's a good or bad idea. And if it's a bad idea, they can help you make it a little more gooder than badder.
Right. Yeah, exactly. So if a person came to me and said, hey, I have this set of money, I want to leave this to my grandchildren, just like you said, for their retirement, how do I go about doing that? I would help them set up the document that would be needed. Usually it's going to be a trust, or it could be a trust built in within the will. But I would prefer to do it in a revocable trust and just set it up through the trust and set up all the parameters that you want to have it managed by, and make sure we put the right persons in place to manage the property or the asset until it's time for them to get it.
Okay, we got 25 seconds. What's your last 25-second piece of advice?
My last advice would be to take control over your future and destiny and get your documents put in place. Because if you don't do it, the state of Florida is going to make decisions for you, and you may not want that to happen.
And you don't want them to take the money you worked hard for.
That's right.
Thank you, Ruth. Thank you for being here today. I enjoyed it. It's a good show because we haven't focused on any one special thing. It's been good.
A smorgasbord.
Smorgasbord. I'm Joe Steckler. Thank you for joining our program today. I'd like to remind you that our senior information line is available to you at 321-473-7770. There you can get help and direction that could be helpful for your specific situation or circumstances. The work of helping seniors is very important, but we can't do it alone. That is why our sponsors here in Brevard County are so important. I'd like to thank our many area sponsors, businesses and medical providers who support the mission of helping seniors that help us carry the cost of our media efforts. If you'd like to join us either as a business partner or simply donate as an individual, we would welcome your call at 321-473-7770. You are always welcome to visit our website at www.helpingseniorsofbrevard.org. Thanks so much for your help. It does make a difference.